Mark Hitchcock and Megan Hitchcock.
Yes, Your Honor, I was coming before the court to ask for the temporary restraining order to be dropped. I'm not a danger to, I'm absolutely not a danger to my children. I'm not a danger to my soon-to-be ex-wife, or anyone for that matter. And it is blocking me from even knowing about how they're doing in school. And as I mentioned, I don't know where Megan's emotions are coming from, but she has not told me where Liam goes to school. She refuses to answer any questions about the kids. So I'm just trying to do what I can to be in their lives.
All right. There's also let's see. Okay. Okay. Thank you, Mr. Hitchcock. Ms. Bliss, are you on this, or Mr. Zandy's on this?
No, it's me, Your Honor, and please the court, I do represent the respondent, non-moving party to the motion before you today. Megan Hitchcock, we did file for your review my client's responsive declaration to this motion back on March 20th. And I think she lays out some pretty significant grounds for why she's asking the order to remain as is. I would note from a legal and factual basis, we think the affidavit on its face is insufficient. I don't think it complies with what the law is as it relates to that. It's the restraining order that was entered last summer by Judge Hahn. And this is a case in which at the time Mr. Hitchcock was represented by counsel. Both of them appeared at the hearing. Mr. Hitchcock submitted a 9-page declaration on his behalf, which pertains in large part to the request for not only the restraining order, but also as it related to the care and visitation of the children in this matter. And the court found sufficient grounds to grant the restraining order, and to suggest that that be set aside because he had insufficient notice, again, flies in the face of reason. Also doesn't comport with what the pleadings will provide for you, which is he was present, as was his then attorney. Now, there was no motion for reconsideration. Matter has sat idly by since it was entered back in August. And again, here we are now in March, Mr. Hitchcock representing himself, asking for a relief that just isn't afforded under the statute. My client does give you grounds for why we believe that that should remain in place. Now, this is a case in which Mr. Hitchcock was court ordered back in the summer to undergo a psychological evaluation with input from the GAL, who is Ms. Height, as well as my client. And to date, my client has received no information pertaining to that. Now, she hasn't been contacted by any providers. We certainly have not received any kind of written documents or any kind of evaluation on Mr. Hitchcock's behalf. And that is still largely up in the air and has not been complied with. At minimum, we should see what the results of that psychological evaluation are before we address these types of issues. My client also gives you information about the snowmen. Understand, after reviewing Mr. Hitchcock's mother's declaration, that she's claiming to be the person who dropped those off at the home, but that was obviously concerning to my client, in which she responds, returns to the home after dropping the kids off at school, and there's on a day where there's no snow in the lower elevations of Longview, 3 snowmen. Checks the video cameras and views what she believes is Mr. Hitchcock's car pulling up, and someone who's can't be ascertained who it is, and puts 3 snowmen on the front yard while the kids are at school. That's highly unusual. That's bizarre. There's been other communications that have her concern related to Mr. Hitchcock. As she states for you in her declaration, there is fear from her that he continues to surveil her about her comings and goings and where she's at. Continues to violate the order, and the order is very specific. The only communication is over the parenting app as it relates directly to the children. And Mr. Hitchcock is basically try to relive old memories with her, again, addressing things related to the relationship and the past relationship during the marriage. And again, my client obviously has a sense of uneasiness when it comes to that. Now, given where we're at on this, doesn't make a lot of sense from my client's perspective to eliminate this or terminate the restraining order, which again has been in effect for some time. If you look at the terms of that restraining order, you'll see that it's set to expire in late May of this year. Again, that's 2 months away. One could logically assume that it probably makes the most sense in judicial economy to just let that ride itself out until May, work towards getting that psychological evaluation, see what the results of that are prior to making any decisions on this. But again, this kind of goes to my client's concerns about Mr. Hitchcock's emotional and mental well-being at this point. And we're at a point now where we're erring on the side of caution and safety. It makes the most amount of sense. And that's what my client is asking you to do today. We do believe this is improperly before the court. This is now the third time we've been here in the last month and a half or so. Court did not impose any fees at the past 2 hearings, which were related to discovery issues from Mr. Hitchcock. We are asking the court to contemplate some award of attorney's fees and costs. It also informed the court, as you probably know, that there's now a pending another compelled motion that Mr. Hitchcock has filed on his behalf. Instead of consolidating these matters and hearing these in one judicial proceeding, we're now forced to come back not only today, but again in a week or 2 on the compelled motion. It comes at an expense to my client. She simply can't afford it. We are asking for a contribution towards fees and costs.
Your Honor.
Mr. Hitchcock, before you speak, I'd like to hear from Ms. Height.
Good afternoon, Your Honor. I do believe that it's going to be in Mr. Hitchcock's best interest to get that psychological evaluation. I think that will provide tools for him going forward that will help him in the future when he parents these children. So I feel like we need to wait until we get that. I think it's going to be in everyone's best interest. I did review the information about the snowmen. Frankly, it seemed silly to me that it became an issue. The picture that I saw was basically a few snowballs in somebody's yard. It didn't seem threatening at all. However, I do understand that having him or someone on his behalf, if that's what happened, show up, that is troubling and should not happen. I'm not sure that there was any kind of evil intent by grandmother's part. I think it sounded like kind of a spur of the moment idea of hers, and I don't find it particularly troubling. However, I don't think that rescinding the orders that are in place now are in the children's best interest at this time.
Thank you. Mr. Hitchcock, you may respond.
Your Honor, just allow me to compose myself. I'm sorry for laughing earlier. Earlier in this motion, not in this motion, earlier in this court, we heard somebody talking about a psych evaluation that was ordered December 7th of 2022 they have not had that yet. The psych evaluations are out over a year. I got on the list as soon as I can. Ann knows that. Confused why Ann is here speaking on behalf, because she told me that she's done with this case. Furthermore, I've never broken that restraining order. I'm not crazy or dumb enough to go anywhere near Megan. I only found out that my mom did when I got Megan's responsive declaration. Again, I will go back to the original matter when she did write her declaration. She did perjure herself, which she does over and over again, but she said that Ann Height directed her to not bring my son to visits, and he wasn't coming, and then she made excuses for that after it came forth that that Beth Fellows didn't have her. So she took this one herself to keep my son from me in my supervised visits, and then used that as an excuse to further push me away from my children in a restraining order. As well, the fact that she says that she has video evidence where she clearly sees my car. And then again, where she says that she is certain that I'm surveilling her. Your Honor, I have had that car since July of last year. Megan and I we've not seen each other since that time. The only way Megan knows what my car looks like, one, is to surveil me, and two, my car was not there. It was my mom's, as she said. And there's been like 3 times my mom has driven my car, and I asked her, she said she's certain it wasn't my car that she took that day. Then when I revisited Megan's testimony to find out where I was, what I was doing, she says on February 20th, the kids had late start due to weather. February 20th was President's Day. There was no school. And before I found that out, before I realized that, I checked, and I was out of town that morning of the night before. And then I did call the school, and I just called Longview School District, because once again, Luke's school won't talk to me about how he's doing or what's going on. They said the only late start was February 16th. That day as well, I was out of town. It's not my car. Megan purposely, once again, she is lying about this video. Neither my car nor I was there. My mom and I both have a red sedan, but it's very different. My mom drives a 2007 Chrysler Sebring. I drive a 2018 Ford Fusion. Once again, I've never broken that restraining order, and my car was not there. And once again, Megan's doing everything she can to push me away from these children. Luke is 5, Liam is 4. Mario will be 3 soon. Every time I see Liam, he has to come to my house. Luke sometimes cries when he leaves visits. I'm concerned about their well-being, and I'm just trying to check up on them at school.
All right, thank you, Mr. Hitchcock. So we're not here to decide whether the restraining order is entered in the first place. That was determined almost a year ago on whatever facts were before the court at that time. I didn't make that decision, but I come to this case with the restraining order already filed. Mr. Hitchcock has asked that be dropped. I'm going to deny that request for 2 reasons. One is it's going to expire on its own terms on May 24th. That's not that long from now. And it may happen, it may not, but if Ms. Hitchcock asks for a renewal, then all of the arguments that Mr. Hitchcock has discussed with us today would be relevant in that discussion. But because it's going to expire relatively soon, I think it should remain in place. Secondly, both Mr. Zandy and Ms. Hyde have indicated that there needs to be a mental health evaluation. I did see that in the file, and apparently one has not been done since it was ordered. And the court is hesitant to make any changes until that evaluation is done. So what I would suggest, Mr. Hitchcock, is I think you should get the evaluation done. I think you should anticipate that Ms. Hitchcock may be asking to renew that restraining order, and it will be helpful to the court to have a mental health evaluation done before ruling on that renewal motion, if it's brought. But I think we should look ahead, and I'm going to encourage that you get that done as soon as possible. Otherwise, for today, I'm going to deny the motion to lift the restraining. Okay.
Could you just enter a bench order to that effect, Your Honor, so we don't have to come back?
I will do that.
What does a bench order do?
It's an order that I draft that will say simply that I denied the motion to lift the restraining order.
Okay. I do want to say for the record that what Megan is doing is hurting these children, and that is my primary desire is to help my children.
Okay, I accept that, sir. Okay.
Thank you.
Thank you. All right, that brings us to our last matter. Just want to find something here. All right, Shannon Mobbs and Serena Doss.
That matters, Freddie, Your Honor.
And
Yes,
I
Your Honor.
think we're going to be making some of the same arguments in this case. We just did, so let me get to my notes on it.
Should I have been paying more attention? Is that what you're telling me, Your Honor?
I'll try to keep it more brief than I usually am.
That's not good news, Ms. Winkles.
Well, you haven't heard me go on and on until I realize everybody's asleep. So
But
I will try to keep it brief.
I come from an era where we always went on and on until the.
Oh, yeah, no, it's on and on. I'm going to keep it brief, though, I swear to you, considering the time.
Well, we're the moving party, so I'm gonna string that. Oh, we're not the moving party, I guess.
All right, I think we're here on kind of similar orders, the temporary order, parenting plan and child support. Are we going to argue all those issues?
Yes. Yes, Your
Okay.
Honor, we're going to argue all of them.
So as before, just tell me what issue you're going to argue about it so I can write down
Okay, so
a head and a header, and then I'll I can take notes after that.
okay, so first, Your Honor, I'd like to argue the parenting plan.
Okay.
And essentially, this is a case of an older man that got, essentially had a child with a younger woman. And the issue here, we have a couple of issues.
Okay,
yeah.
Go ahead.
The parties were together since 2019. Mother had a significant issue with kratom at the time. And I'm not sure if Your Honor's aware, kratom is really what can only be called an opiate. And it has essentially the same withdrawals and the same issues as opiates had.
I'm gonna object, Your Honor. The Google search utilized as the basis for this opinion is not an expert opinion. Counsel has cherry-picked the Google search to include what is favorable to her argument on what kratom is, and kratom is sold in grocery stores. So that's a sideshow that shouldn't drive the.
Okay,
I get to make my objection. Sideshow that isn't.
Mr. Sosa, let's have some ground rules right now, okay?
Okay,
I'm gonna let Ms. Winkles make her argument. We're not gonna interrupt it. And then you're gonna have all the time in the world to tell me that. If you have an objection, for example, hearsay or.
correct, hearsay.
Okay, then I'll address that. But I don't want a discussion going on. I want to hear from Ms. Winkles and then.
So do you want that objection made during my presentation then, or now? Because it's hearsay and lack of foundation.
Okay. I'm gonna take that.
I'll do it how you want.
Here's the deal. All of this was in the pleadings that I've read. I'm not going to unread them, but I am going to ask Ms. Winkles not to spend a lot of time talking about kratom because I read your pleadings.
And I won't. I will just say to the court that I went to medical school before law school. So a lot of this is just basic common knowledge on the ingredients in kratom.
Yeah, but you're not the expert here.
No, and I'm
able
not. This comes from the
testify.
And this comes from the FDA, and this also comes from essentially no Google search. It comes from the literature on the drug of kratom. But I don't even need to go into what kratom is to have this argument.
Counsel,
So I will ignore the definition of kratom from the FDA. I'll ignore the National Health System, their concerns of kratom. I'll even ignore the fact that they tried to outlaw kratom in the United States and make it a class 1 drug. So I'll go into everything else. I don't even need to touch on any of that.
I guess we got our kratom discussion anyway.
Mr. Sosa, I'm
I'm
going to
sorry.
say it one more time. No interruptions. If you want to say objection, something, fine, but no comments like that, all right? All right, thank you.
Objection, hearsay and foundation.
All right, I will note those objections. Thank you.
So
Let's go ahead.
thank you, Your Honor. And so in 2019, these parties got together. There's a significant age difference between the parties, which I think is relevant in the longevity of the relationship. Mrs. had a problem with alcohol, had a problem with opioids, essentially took kratom to get off those opioids, had the child while she was pregnant. And you'll see from those medical records, while she was pregnant, she disclosed that she was on kratom. The doctors were concerned enough to put her on Subutex. And what Subutex is it is a synthetic opioid essentially used by the medical community in order to get people off of opioids. The child was
Objection,
born.
lack of foundation, and hearsay.
Again, the medical records
Noted.
show that. I'm sorry.
Go ahead.
The medical records disclose all of this. This is not my client's testimony. This is purely from those medical records that we've given to the court. Essentially, these parties had a difficult relationship. Mrs. The mother went off, and it's really a difference in age groups. The mother essentially disclosed she couldn't have a child. She got pregnant. As soon as she had a child, she would go off to Seattle. She would visit her friends for multiple weeks on end. My client, you'll see from the text, my client would repeatedly ask her to come home. She would come home. These issues would continue. You'll see from the text messages, which I think are really important in this case, that there was no domestic violence at play at all in this case. You'll see from the 2019 text messages between the parties, Mrs. has said that it was this horrible blow up, that there was violence and she had to hide and run. You'll see from the 2019 text messages between the parties that this was not the case. She essentially was kind of annoyed to be around his friends and family, but really there was nothing else other than that. There was no violence. There was nothing. They essentially drove to a family reunion. They drove back. There's nothing. We see the same thing in 2020. We see absolutely no violence. On the date she says that there was this massive domestic violence incident, we see the parties talking about how they can be better parents, how they can be better to each other, but there's no violence. There's absolutely no violence. We then have 2022, and this is kind of where things go awry. The mother of the child essentially decided she didn't want to be with the father. And rather than going through the normal channels and trying to work out some sort of parenting arrangement, work out some sort of co-parenting of any sort, she essentially takes the child, says she's taking the child to daycare, calls the daycare, tells the daycare she's not going to be dropping the child off, and then immediately leaves the area and goes towards the Seattle area. She refuses to give her address. She refuses to allow father any visitation. She essentially has a control on the child. All father wants at that point, and you'll see from the text messages, is to see his child. This is a man who took 12 weeks off from work, and mother says she was doing everything. When somebody has a C-section where they're cut into their abdominis rectus muscle, that's physically impossible. Dad is there taking care of this child every day. Mother has had a cesarean section where she's essentially been cut open and had organs removed and replaced. Dad is there every day. Dad is there working with the mother to try to find out the best vaccination schedule, the best way to deal with this. Now, dad is older. Mom says that he's a misogynist. There is a different time period here. Dad's not going to deny that maybe he's not as woke as some other people. But dad's trying. He's really trying to do what mom wants and to kind of work with her. Mom takes child. Mom's gone again before she's pregnant, significant amounts of time. When she has the child, she takes the child to Seattle. She's gone for weeks on end. Dad apparently is putting up with this and is just happy when mom is there. Mom finally again says she's taking the child to daycare. She takes the child to Seattle, cancels daycare. Dad never sees child again. Dad is calling mom. Please, I just want to see my kid. I just want to see my kid. Mom is like, no. Mom doesn't give the address. Mom doesn't give anything. Suddenly the discourse changes to domestic violence. The thing is that dad has saved every single text message because he realizes that there's been a significant change in essentially what has been disclosed between the two. And he is concerned that this is now going to be the discourse. So you see in the 2019 where mom says she was beaten up, that's clearly not the case. You'll see from them, they're talking about dogs, they're talking about people they don't like, they're talking about all kinds of things. 2020, it's the same. In 2022, when mom leaves, mom claims she was abused and she fled. You'll see from the text messages that mom admits that she had a meltdown. And dad's not blaming mom. Mom is a new mom. Mom, postpartum depression is a real thing. Dad is saying, look, your meltdown was an issue. I want to work with you. I want to be a family. And mom says, essentially, I understand, and it acknowledges the meltdown. It says, yes, I had a meltdown. I'm tired. I'm exhausted. This is a new mom that is young, and dad is trying to understand this. And mom leaves. And this is where the problems begin, because dad just wants to see his child. He wants to have a bond with his child. There's no domestic violence here. There's no issues here whatsoever between these two. But mom decides she's going to start this new life independent of dad. She wants dad erased. She wants this child and her to start this new life in Seattle. And Longview no longer exists. But dad is just begging her, and you'll see in the text, begging her, can I see my child? Can I talk to my child? Can I have any sort of connection with my child? And mom will give him some, but the mom is in complete control of this. The mom says, I heard that you started seeing somebody else. You're not seeing this child at all. And that is the problem. And the problem is that in order to have a co-parenting relationship with the child is adequately protected and adequately given both parents, it means that both parents have to be willing to work together. Dad has, you'll see the text messages, and which there are a lot. Dad is willing to essentially do anything mom wants in order to have this co-parenting relationship. Whereas the moment mom thinks dad is dating somebody, seeing somebody, anything like this, mom essentially pulls the child away. And that's why we're here. This should be a case where both parents can agree to parenting this child independently and parenting this child and coming up with a parenting plan without us. To be honest, it's expensive to hire lawyers, and frankly, in this case, it shouldn't be needed. Dad is living further away. Dad should get weekends. Mom should get weekdays. It should be something of that nature. But that's not what we're here, why we're here right now. What we're here for is that mom has decided that dad has no input, that this is dad's child, but dad never gets to see. That dad is completely controlled by mom's whims. When mom gets upset, child doesn't get on the phone. When mom gets upset, dad doesn't get to see child. And the other issue is the kratom issue. And while we can say that kratom is legal, marijuana and alcohol are illegal. Mom has had a significant issue with kratom, and kratom acts like an opioid in large quantities and acts like an amphetamine in small quantities. Mom is taking this and living the party lifestyle. Mom is young.
Objection. Foundation not following the court's ruling, and she's testifying.
Okay, so noted. Thank you.
And while it's understandable given the age gap, the fact is, while we've asked for complete custody to dad, dad doesn't really want that. Dad wants to work with Miss Moss and come to a way that they can parent this child, because they both have a lot to offer here. Mom is, mom and loving and nurturing. Dad gives a stability, gives, essentially he's already had a child, and he gives kind of a different slant to mom as a young mother. Dad is an older father. They both can really, the child can really benefit from both of their inputs in this child's life. Now, mom shares texts, apparently, and we've objected to. There's texts of what his daughter said when she was 17 years old, and states that he beat up the child and the police came. The fact is, no police reports have been filed. Dad will state that when we eventually get them, and I believe we both have requested them, the police reports are going to show that my client's 17-year-old daughter at the time was essentially chastised for being out of control if dad had actually quote unquote headbutted child, dad would be in jail or dad would have a record, and dad doesn't. Dad fully admits that during his initial marriage, when he caught his wife cheating, when he walked in the door and saw her with another man in their marital bed, he took her phone and threw it across the room. That also went through 1.5 years of
Objection,
counseling.
Your Honor, relevancy, out of relationships such as that are not part of a parenting plan evaluation under the statute.
And Your Honor, if I can reply, I'm not sure why they brought it up. I'm merely responding to what they brought up in their reply. They brought up this quote unquote assault charge. It was not an assault charge. My client has a disorderly conduct charge for essentially catching his first wife in bed with another man.
I think it goes to an explanation of either the father's propensity for violence or not propensity, that, to show the extent that something happens, that what he does is throw a phone. I think it's relevant in that assessment. So I'm going to allow it.
This is a man that, if you read the text, has tried everything in his power to get along with Miss Morningstar. He wants to have a decent relationship with her. He understands now it's over. He's not happy about that idea. He would still, to be honest, he would take Miss Morningstar back, but he understands it. And so what he wants now is to do a co-parenting. He doesn't want to take the child away from her mother. He would like her to stop using kratom. He would like her to go seek treatment for kratom addiction. My client states that she has a significant drinking addiction when she's not on kratom. So it's kind of one or the other. She's either drinking vodka or she's taking kratom. Neither one of these are good for the
Objection, Your
child.
Honor, as to the kratom and the vodka. No foundation, counsel is testifying.
I think there was discussion in the father's declaration. So
Page 2,
Okay.
lines 1 through 20.
I'm going to allow it.
My client would like her to get treatment. However, it's unclear if she's actually addicted to this or if it was mere boredom and this sounds terrible considering we all live in Longview, or if it was mere boredom being a young woman in Longview. My client understands that living with somebody his age might have been quite boring for her, and that might have led to this. He doesn't know. In any event, he would like her to have an alcohol evaluation or a drug evaluation. He does claim that she started using kratom immediately after the child was born again, got off the Subutex. You'll see that in the medical records. My client doesn't want to change anything in reality. My client just wants to see his kid. He wants to see his kid. He wants to have a bond with his child. He has an amazing relationship with his daughter. When she was 17, she did freak out. She called the police. The police came. Nothing happened except she was chastised. He has a very good relationship with his older child. He would like to have a good relationship with this child. And you'll see from the text messages, my client feels that this is the case of Miss Morningstar wanted my client to essentially kick his older daughter out and put her first. And my client chose his child. And that really upset Miss Morningstar. And that was enough to end this. It was me or her, and my client chose his child, which in relationship terms may be a problem. But in terms of being a parent is probably the right choice. He would choose his child every time, and he's still choosing his child. And my client would ask for visitation on first, third, and fifth weekends of every month. If not complete visitation and full custody. And by that, I mean, we would ask that she have an alcohol evaluation with collateral input from him and collateral input from other people. You'll see from the text messages, my client's not the only one that's concerned. We would also ask for, and this is the problem, is kratom is one of those drugs that is so new, we don't have a test for it. We don't have anything for it. My client would ask.
Foundation, counsel is testifying.
Noted.
My client would ask for some sort of input about kratom usage, and that Mrs. essentially given alcohol and kratom evaluation and that we see where she's at with that. My client is willing to pay child support. The numbers are off. We've submitted his financials. Now, they've stated that we haven't submitted his current year, and that is true. My client has requested them from HR, and we will submit those as soon as we get those. He does work for Intel, and it is quite difficult to get those pay stubs. They don't send them on a weekly basis as they would in any normal job. We've requested them from Intel. As soon as we have them, we'll put them in. The rate has not changed since 2020. He's willing to pay child support. You can see in his text messages that he says, "Why are you on WIC? That's my job. I'm the one supposed to take care of you guys. I'm the one that's supposed to do this." The problem is when he's not given an address, when he's not told where anyone is, can't even support his child. This is a case of withholding to the utmost extent. Judge Fassett, when she listened to the docket, she stated that she couldn't even understand why this man was not given any visitation, that it did not appear to her to be anything even close to the level of requiring
You're saying
supervised
unless
visitation.
she's read the record or something?
Well, I have too. Judge Fassett ordered 4 hours unsupervised visits before today. Did that occur?
Are you asking me, Your Honor?
No, I'm asking Ms. Winkles.
Okay.
It did occur, and on that, we'd ask that visitation occur in Kelso. So this is the issue. My client has a dad that's elderly and who's on his way out. My client would like to take this child to his father's house to have visitation with the child with his dad. He's very, very close to his own father. He'd like the child to essentially be close to his dad too before his dad passes away.
Where did the 4 hours occur this last week?
I would need my client to
Sunday.
which location?
Where was it? Up in
Olympia.
Seattle?
It
Olympia.
happened in Kelso.
Oh, it was in Olympia.
Yeah, we met.
Okay.
And so we'd ask for it to be in Kelso. My client's willing to pay for her gas. My client is willing to pay for her gas mileage to get down there. He just wants to have this child with him for, he asked for overnights. There's no reason not to have overnights. This is a man that took 12 weeks off work at Intel to take care of this child and his partner while she had a C-section. This is a man that is willing to essentially do anything, and you'll see from the text, anything she wants to have this child overnight. There's nothing in his record. There is nothing that says that he can't do this. His daughter lives with him, has a close relationship, still his adult daughter. There's no reason for this. We'd ask for first, third, and fifth weekends of every month. And we'd ask that she has a SUDS evaluation with alcohol, with collateral input from dad. We'd ask that he gets 2 weekends a month. Otherwise, we'd ask for full custody because dad is concerned, but we want to give mom the benefit of the doubt. He wants to believe that she is going to be a good mother. He wants to believe that that's a possibility, but if not, dad has already set up everything in order to have full custody of this child. We are very concerned that mom's lifestyle is not commensurate with having a child, and that is what we're asking for today. Thank you.
Are you going to address spousal
child
support or other temporary, not spousal, but child support?
So just to quickly address the CIR, in order to have a CIR, the case law is very clear. You have to share debts and share assets.
Well, they're not asking, but they're going to amend, aren't they, to allege that? We're not going to take that up.
Okay, so we won't take that. So dad has provided his pay stubs. Dad is requested more from HR. Mom works. Mom has significant income. We have put in mom's income now that we have it from her pay stubs. My client's worksheets are accurate. My client provides medical care for the child, provides all of that. The worksheets that my client have done have absolutely been accurate.
So you've got an obligation of $1,012.12.
Yes, and my client is willing to pay that. My client has no issues paying for his child.
Okay. Okay,
But again, just to add, my client is very concerned of the kratom and alcohol usage. My client says this is a woman who starts drinking very early and continues. And you'll see the text messages from that period about that. My client would just like her to have a SUDS evaluation. My client's not alleging she's an alcoholic because frankly, he's not sure if it was just a response to what was going on in her life at the time, or whether or not this is a significant issue. But he believes that we need to get a little bit more information.
okay. Thank you, Ms. Winkles. Mr. Sosa?
Thank you for your patience, Your Honor. And first of all, let's take the age scenario. We're talking about 49 versus 39. This is not May December land. We are not talking about a young mother. No offense to my client. We're talking about a woman who at 36 or 37 had a child. Under no definition is that a young mother. So this whole age thing, as if this is a gold digger or something, is absurd, and none of that is relevant to parenting or to child support or to attorney's fees, which are the things we're arguing. Yes, he took 12 weeks off and took off hunting right after the birth of the child. So couldn't have been that big an interest in being there every minute of every time as far as the child is concerned. So, and the text messages are very interesting because it is misogyny, and some would say worse, it's harassment, because he would talk more about who she was dating and inquiring about that. These parties are separated. Why is there this inquiry? Why is the domination all about that? More inquiries about who she was dating or sleeping with or whatever, as opposed to the care of the child and wanting to be around the child. So let's do it right. Let's take everything into consideration. So when you're looking at all that, yes, the prior judicial officer did order time, and not only did my client facilitate that time, but when Mr. Mobbs had basically had a fit, saying, no, I want to take him to see my father, despite the fact I love my grandparents. Grandparents should be a part of kids' lives, but in our state, they don't have any rights. But what did she do? She withdrew any restriction of travel time so that he could facilitate that and take to see grandpa, okay? And so we assume that happened. And yes, the visit ended up in Kelso. The exchange was in Olympia. So that's what really happened. So my client did not obstruct, and after being harangued by Mr. Mobbs, which is his custom, did provide the extra time, which she didn't have to do, because it doesn't say 4 hours excluding travel time. So what are we proposing? First of all, we do want a DV evaluation. I appreciate counsel's advocacy. I appreciate her medical education, such as it may be. That still doesn't mean she gets to opine as to what kratom is, what kratom's about, and all that stuff. And the majority of this argument has been about kratom, trying to create some sort of requirement. So what do? We go and get a hair follicle test with an ETG component, which covers the alcohol, and it comes back clean as a whistle. I'm not saying that's the Oracle at Delphi and the be all and end all, but guess what? If she's using the kratom, as much as being said, that would come up, because this court, I'm sure, has seen kratom come up on certain type of alcohol or drug evaluations. I'm sorry, not evaluations, but testing. And likewise with certain sorts of testing, such as urine tests, as opposed to the hair follicle or nail tests. So she's put her money where the mouth is, or mouth where the money is, whatever the phrase is, and is in a situation where saying, I'm not drinking excessively. I'm not using kratom excessively. That's the majority of what we've been talking about. So at the end of the day, there should be an evaluation for DV. And as this court knows, because of our new statute 7105-010 et sequitur, that statute provides all sorts of events that create DV. And A lot of the events probably occurred prior to the new statute in July of last year, but some have continued to and do continue to. And yes, the reason why she was in a situation where she had to get extra money was because he wouldn't provide her with any money, which is part of the coercive control aspects of DV. So we haven't filed a petition for domestic violence. We want an evaluation. And if the evaluation doesn't show that he is a prospective DV perpetrator or has been, then for that point, he's cleared. So there should be no fear on his part to take the evaluation. And so I think that's a reasonable request given the history. And as the court noted, when I was blundering into your discussion about the daughter's allegations, throwing the bottle at someone, I think all over our state, that could be DV under certain fact patterns. It is not a reasonable response to anything, throwing anything, especially a bottle, at anyone. So there are concerns about DV here. So instead of rushing back to you or whoever hears those DV petitions down in Cowlitz, we're asking someone who knows what they're doing to give an evaluation, and maybe at a minimum, there'll be some tools that Mr. Mobbs can be provided with to treat people better, to communicate. He wants to co-parent while he's beating her up literally and physically, literally about who she's dating. That's DV. That's DV under the statute. But we're not running into the courthouse to get a petition. We're saying, let's take a look at that. If he's who he says he is, and more importantly, if he is who counsel believes he is, then he should have no problem acceding to an evaluation. As far as my client's evaluation, I think she has shown by being proactive and getting not just a P-test, but right out with a full panel ETG test. And it was clean. That means something. You put yourself out there when you take those, because it goes back 4 to 6 months, even with alcohol, if it has the ETG component. So we've done that. We've provided that to the court. We're addressing these issues as far as that's concerned. Now, as far as the parenting plan, it's undisputed until the declaration that my client has been the historical primary parent to the child. And it is in the child's best interest to maintain the status quo. And that's what my client is by providing the majority of time. And we get a mixed bag from Ms. Winkles in her argument, because she says, well, we want this, but we really don't want this. But if this happens, then we want this. And if we can't keep badgering her about her sex life and who she's dating, then we want this. Well, you got to pick something. And I think our pick is what historically has happened. It's the tradition in this case. And, Mr. Mobbs, I don't think he's of advanced age, especially since I'm way older than he is. But what I'm saying is, it's not an age thing, it's a lifestyle thing. And the lifestyle that he's choosing to live also consisted of running off to go hunting. And I'm not a hunter, but I know people love their hunting, and I get it. I'm not a gun guy, but I'm a Second Amendment guy. Everybody has a right to have them. So what I'm saying is that as far as that's concerned, if he really cared about trying to establish something with his child during the 12 weeks that he was off hunting or doing other things, he wouldn't have gone that way. The phased-in parenting plan, I think, is a good approach. I think one of the things we have to find out is Olympia our best place to do the exchange? We do want, at a minimum, a lay supervisor that we can agree on, family member, friend, whatever, at least at the outset, or at least until we get the DV evaluation results back. Hopefully we can agree to a lay supervisor, but I don't think that this gentleman should be unsupervised at this time. As far as as far as the other issues, I think you've got the parenting plan there. We've discussed the substance abuse issues. And if we can go to child support. I looked through the file, and Ms. Maines, my associate, had started the file. She had a conflict today, so I'm arguing. I did not find any proposed child support worksheet from council. I did not find any, excuse me, service of recent pay stubs. What we do have from a financial standpoint, and we're served with, is the 2020 W-2, I believe, of Mr. Mobbs, which my associate calculated the child support dividing by 52, the gross amount, and then multiplying it by the factors and coming up with the gross income, which apparently council doesn't think is an error, because I don't see another sheet, nor do I see that. And so without having that, I think our child support number is the correct one. I think our worksheets, and I know that Cowlitz County, under your local rules, do not require financial declarations, but it would have been nice to have one from Mr. Moss, because it gives us a complete picture of what his assets are, what his liabilities are, and what his obligations are, as far as his monthly nut for living, where he lives. None of that was provided. Instead, well, I'll get it from HR. Did he not get a W-2 for 2022? It's the end of March. Why can't that be produced? I don't understand what the difficulty in it, what difficulty it is. So I think there's an attempt to hide the ball on what the real income is and about what the discussions are. So I would ask that, and by the way, as far as the temporary family law order, I think the parties keep the items that are in their possession. They're basically separated right now and have been for a bit. I think you should enter our child support order. I think a temporary parenting plan should go into place, but not the first, third, and fifth weekends. And at one point, Mr. Mobbs, I think, took advantage prior to the alleged withholding, which isn't withholding because there was no parenting plan. So I don't know how you can call it withholding. But in any event, he complied, or my client complied with the judge's order and complied in overdrive. And yes, co-parenting would be great. It's great, but we got some problems here. First, there has to be some communication issues that need to be ironed out, because I don't care who you are. You read those texts from Mr. Mobbs, and that is not how we communicate in a co-parenting relationship, let alone any sort of quasi-loving relationship. Those are rude, and it's not just rudeness. Those are texts that are inquiring about stuff he has no business inquiring about, because sex life is not an issue in parenting plans. It's not an issue, of course, in division of property, as we know, because fault, perceived or actual, is not brought into that process. So they're trying to create a huge nothing burger out of a nothing burger. We're not asking who he sleeps or even with, or if he's even sleeping with anybody, because we've moved on. We don't care. But that seems to be what I heard in argument. Someone's sex life, who they're sleeping with, their kratom, it's not kratom, I think it's kratom. But by the way, we really don't want to change anything. Yes, we want full custody. I don't know what that means. So, I don't know what happened last week on the hearing. I wasn't there. Maybe it wasn't presented in a way that the judge felt was proper for comprehension. I'm not admitting that because I wasn't there. What I'm saying is the judge made a ruling, and the ruling was a good one. Yeah, give him a shot here. Let him do it. We gave him a shot, and the co-parenting to be, verbally abuses her to the point about the grandpa visit, which was not part of the plan. And what does my client do? What a good co-parent would do after being verbally abused. She decides to go ahead and say, okay, we won't even count the travel time. Go take him to grandpa. She's not evil. She doesn't want grandpa not to see the kid or not be a part of the kid's life. She's not worried about grandpa. She's worried about dad, because dad's saying and doing all sorts of things. She's being accused of being a gold digger and a sex addict, or whatever you want to call it. Those aren't relevant, and they're not factual on top of it. So we would ask for our temporary parenting plan, which is every other weekend. We start out lay supervised. I think it was 4 hours that we're going for on a Saturday. So it'd be every other Saturday, not 1, 4, and 5. Those fifth weekends, Commissioner, I just don't know what your experience is. I'm sure it's considerable, but what I'm saying is they cause more problems half the time than they solve. People don't understand if that Saturday starts the fifth weekend, or we got one coming up this week. You know, the first is on a Saturday. So is it the fifth weekend or what is it? And let's do the slow walk, because I don't think as much as he wants to see his child, you know, he's making all these allegations. There was no immediate restraining order on the alleged withholding issue where there's no parenting plan. So a lot of smoke and mirrors here. Yes, we may have 2 good parents, but we don't know that yet. Okay, what we do know is this child needs both parents, but dad needs an evaluation. Dad needs an evaluation. That's not going to hurt him. That's going to help him, whatever way it comes out. And more importantly, it's going to help the next judicial officer, whomever that is, decide this case and form a parenting plan, because it's a temporary plan. But we got to do some things, or we're just going to be floating in the abyss here, having more abusive texts, having more harassing texts, having more sexual questions that are totally inappropriate, and in my view, an element of the DVPO statute as currently constituted. None of his business. Move on. But you know, that's not putting the eyes on who needs to be taken care of, and that's the daughter with the beautiful name of or Isabel. Sorry, and she deserves both parents, but not how Mr. Mobbs is currently acting, and hasn't changed. And the text about her going to need money is because he wouldn't give her any money. And it's from 2019. This isn't stuff that just happened as part of a very hotly contested divorce. This is stuff that's been going on for years, which is why she left in the first place. So now we got to put the pieces back together for the child so that she can proceed to get the best of both. But we got to find out what's going on. We've already taken that step, Judge, and I'm almost done. We've already taken that step, and by getting the hair follicle test and the nail test. And finally, Your Honor, we're asking for we're asking for $5,000 in attorney's fees. Just on the platform today, it's been 3 hours, and you know, interesting stuff. But that's 3 hours right there. This is going to be charged at my associate's rate because it's her case. And we are entitled to attorney's fees to level the playing field just on the income disparity. You know, we have a gentleman who makes grosses probably $8,000 or $9,000 a month. We don't know because we don't have a current W-2. And we have a person who is making $32 an hour. He makes double, almost double and half what she makes, and always will. So let's get started on that. Thank you.
What's your child support number, sir?
It was 1,012.
That was what is. Oh, I'm sorry, 1,012. Okay.
Yeah, and I don't think council objected, right?
Do you agree with that, Ms. Winkle? Is that number?
Well, Your Honor, we're asking for more visitation, so we would ask for a deviation based on the fact that we're asking for more visitation. Additionally, it needs to be noted that my client also pays for insurance of the child, which lowers that number. My client pays for a significant amount of expenses. So we would actually ask for I believe we put in a proposed order, so we'd ask for that order to be entered.
I don't believe I've seen it.
There's no worksheet, Your Honor. Are we doing oral worksheets?
We have entered a worksheet. It's actually on the record. If you go into Odyssey, you will see the worksheet that we've entered into this.
Well, usually I get, you didn't serve that us. We have to go on Odyssey to get it.
We have sent it to your office. We sent it over a week ago.
Well, you're calling my associate a liar then. So that's not what happened, because we don't,
Counsel, we can refrain from those kind of statements. Okay.
well, we just like to see a worksheet, Your Honor.
Your Honor, if I may reply to the discussion.
Yeah, if you can keep it brief, the clerks are supposed to go home at 4:30 and so
Absolutely.
that time. So
Absolutely, I'll keep it as brief as possible.
Yeah.
Your Honor, we have significant text messages between the parties from 2019 concerning vodka. We have significant text messages concerning kratom. This is an issue. We have bank statements that show that Mrs. Morningstar has been buying kratom for a significant amount of time. This is a woman in charge of essentially an infant while she's under the influence of a drug that may be illegal or maybe legal, but still causes the same effects as opioids. And we know this because they put her on Subutex, which is an opioid, while she was pregnant. We have a child that's born essentially with a substance in her body, which is
Your Honor, objection, there is no evidence of
the
that.
medical records are there.
I think they submitted medical records showing that. Go ahead.
We then have a father who is begging mom to see his child. And mom is like, you've been out with this woman, you don't get to see the child. This is the issue. My client has had 50-50 custody in his other parenting plan. He has a very deep relationship with this child. At minimum, this is a man that should give it 50-50. At maximum, should have full custody of the child. Mom wants to party. Mom wants to live this life of kratom, this life of vodka, this life of having a good time. That's fine. Dad is willing to take the child. Mom essentially uses this child as a tool. She's not telling dad what the child's doing. She's not allowing dad to talk to the child. This is somebody that does not have the child's best interest at heart. She is not thinking that this child needs dad. What she's thinking is she's going to punish dad by using the child. That is absolutely the wrong way to think about things. Dad has tried to involve mom in everything. The fact that dad had 50-50 custody, even after the quote unquote disorderly conduct, says everything. Dad's relationship with his current daughter, she's lived with him. She's actually been in the house and lived with him. And mom had a problem with this. And that's why mom left. You'll see those text messages. At this point, dad is saying, look, I want to work with you. I'm asking for full custody until you've had the SUDS evaluation. After that, as long as it comes out clear, then we can move forward to a 50-50 plan, a first, third, and fifth with additional days during the week. Dad's schedule allows for that. Dad's willing to go get the child. But if we're going to do a very limited schedule, then mom needs to come to dad. But the fact is that dad has a job, pays for himself, has no drug or alcohol issues whatsoever. And although mom alleged them, they're not there. You'll see the text messages. There's absolutely no domestic violence. Under 26, RTW 26, it defines domestic violence. It defines domestic violence under the Civil Protection Order. There is absolutely nothing there. We then see an email from mom that says, I think this has gone too far. And what she means by this is that she's essentially made these allegations that are totally inappropriate, totally not what is going on. She's essentially made these lies that she knows that they're there, and she thinks it's gone too far. She's actually asked for dad them to work together. This is not a woman afraid. This is not domestic violence. This is nothing of the sort. And the fact is that he knew she was going to do this. She did it. We calculated it. And dad has proof in text messages that nothing mom said is accurate. That is a massive credibility issue. It shows that mom is willing to go to any lengths to punish dad, not to care for the child, not to have the child's best interest at heart, to literally punish this man. That is a massive problem. That means that mom will never be willing to work with this man. We then go into the pay. Mom is complaining about making over $30 an hour, which is over $70,000 a year. This was a very short-term relationship. Dad has accurately put in his income. Dad has accurately shown what he makes. That is without a deviation. Dad is asking for deviation because dad is willing to take 50-50 custody, which frankly is what should happen here. Dad is willing to do 50-50 custody. His schedule is completely set. He's willing to come and collect the child for this 50-50 custody. And additionally, there will be child support to mom still, since she makes a little bit less. He's willing to do that. Dad is willing and able to do 50-50 custody. This is the type of case that deserves it. Mom has a substance abuse issue. Dad doesn't. Dad is older. Frankly, that's maybe an issue for the relationship. But dad has an amazing relationship with his other child. Dad has a job. Dad is steady. Everything here asks for 50-50. Until this child is going to school, there's no reason for it not to be a 50-50. Dad's willing to come collect the child. Everything here says that this is what it should be. The DV is frankly ridiculous. The text messages they supplied, there's no domestic violence in there. Dad is begging her to essentially take him back. Yes, is he concerned that she was cheating on him at the time? Yes. But that's where it ends. He doesn't call her names. He doesn't abuse her. Nothing in those texts shows anything even close to a level of domestic violence. What it shows is a party breaking up. And it's unfortunate, it's sad, but it's reality. In this case, the fact that mom has manufactured domestic violence where dad can prove it didn't happen. Mom says it happened here, here, and here. Dad shows the text messages, which shows that, frankly, that is absolutely not the truth. It means that mom has a credibility issue. And the fact that mom has a credibility issue and she took the child away and wouldn't let dad see her says that mom is not the primary parent. Mom does not have this child's best interest at heart. Dad is willing to work with mom. That's who should be the primary parent. Person that's willing to work to have a relationship so the child knows both parents, so that the child has this relationship with both parents, and so this child can get the benefit. Mom is not willing to do that. Mom wouldn't even give her address. Dad wanted to send diapers and toys, and mom refused. Dad has never been violent. There's nothing in that. Dad has FaceTimed this child every single day until mom says, nope, not going to do it because you're dating somebody else. That's frankly the wrong person to have control here. The person that should have control here is the person that's, I will share this child. I will share the time with this child. I will share the parenting with this child. That person is my client. We would ask for at minimum, a 50-50 custody order. At worst, a first, third, and fifth, with additional days overnight when my client is off. He has a set schedule every single year. At best, we'd ask for full custody. My client is very concerned of the alcohol usage in the kratom. My client is very concerned that this will adversely affect the child. The child was already born with noxious substances in his body. That has to be addressed. We'd ask that our temporary orders be put in place. We'd ask that dad get at minimum 50-50 and maximum full custody, but mom needs to be involved. Dad wants mom involved. Dad wants both parents to be here. We'd ask for a deviation of those worksheets we put in place based on the time dad has with the child. Dad isn't a millionaire, regardless of what they say. We've requested those from HR. Intel is undergoing a complete change due to the microprocessing.
This is not in the record, is it?
Dad,
about the microprocessing and stuff. Come on.
Dad has addressed that he's asked for the HR
It's
record,
beyond
and we will
reply.
put them in immediately upon getting them.
All right, thank you, Ms. Winkles. Mr. Sosa, I'll give you 2 sentences if you want. You're muted right now, sir.
I didn't hear anything different. Deviation was never requested. We were not served with a child support worksheet. If we violated the rules by not going into the court file and doing that, I'm sorry, I didn't know that would be the way it would be done, and we apologize. But miracle of miracles, we came up with a number that council doesn't object to. And as for the rest of the stuff, it was reiterating. No one's perfect here. She's not what he says, but he loved his other daughter so much that when he got angry, he threw a bottle at her. I don't know if that's the kind of relationship we want. Thank you, Your Honor.
And just a very brief reply. I did object to their additional pages. I do want to reiterate that on the record.
I'm aware of that. Yep. All right, let me make a few general observations that may help everybody understand the decisions I'm going to make. First of all, I think both parties have retained excellent counsel, and you should be happy that you have the attorneys that you do. And the attorneys have a job to do. I believe that both parents are much better than what the respective attorneys are pointing out. Okay. I think both of you love your daughter, and I think you're both better parents than what you would gather listening to the argument today. Secondly, all of the information about kratom is hearsay. There's no foundation, there's no expert testimony, and I really don't feel that it's appropriate for me to accept that. I do accept that Ms. Doss uses kratom, and that will play into a decision I'll make in just a bit. I don't see anywhere, and I think Judge Fassett indicated this last week, where Mr. Mobbs is at all a danger to his child. And I don't see any reason for supervised visits when he sees his child. And the visit this last week apparently went fine, except for the back and forth about seeing the grandparent. So based on that, and given the distance, and let me also, I guess, reflect this, I think it's fair, is that I do have a concern that Ms. Doss took the child for some period of time and did not let Mr. Mobbs see her during that time. And there appeared to be quite a bit of communication during that time between the two. But it really, going forward, it's really not appropriate to withhold the child like that. And one of the places I started, one of the things I emphasize is that both parents have a constitutional right to be a parent and to participate in their kids' lives. And you're going to have this challenge where there's some distance, and you're going to have to work with that. But I think you're going to be able to do it, and I'll try to give some ground rules today. So what I'd like to see in terms of visitation is, I'm going to phase in a bit. I'd like Mr. Mobbs to have visits from Friday afternoon, and if we needed time, Friday at 3 to initially Saturday at 5. And that necessarily is going to include travel time. Initially, it sounded like the Olympia halfway spot worked. So I'd like that to happen.
Your Honor, my client is willing to pay her gas if she can come to Kelso due to the fact that he's also taking care of his aged father.
I'm getting shakes of the head, and I know this is inconvenient for everybody, given the distance. But I think the best we can do right now is have what appears to be about a halfway point in Olympia. So initially, pickup will be Friday at 3, drop off in Olympia will be Saturday at 5. So that will be an overnight. I'd like that to go on for 2 months. And that will be the first and third weekend as determined by a Friday. So to get away from the misunderstanding Mr. Sosa talked about, the weekend, whether it's first or third, is it the first Friday or the third Friday? Okay. So that goes on for 2 months. After 2 months, so that would be April and May, starting whatever weekend in June. Then I want it to be Friday at 3 pickup, and drop off will be Sunday at 5, first and third. I'm not ordering a 5th weekend. I would like the parties to facilitate at least one video call a week. Okay. By the way, I didn't say this at the beginning, and I think I need to say it so the record is clear on my thinking. I think the age difference between the parties, first of all, I don't think 10 years is an age difference. And second of all, even if it was, I think it's absolutely irrelevant to this case. And it has nothing to do with my ruling at all. All right. So that will be at June 1st. It goes up to a full weekend. After 2 or 3 months of that, if Mr. Mobbs wants to petition the court for some additional time, I'll let him do that. I'm not exactly sure how that's going to get built into this relationship, but if he thinks it can be, that'll be fine. All right. I'm not ordering any evaluations. What I am going to order is that a guardian ad litem be appointed in this case to determine what's in the best interest of the child. And if the guardian ad litem, after interviewing the parties, feels some evaluation is appropriate, then she can recommend that to the court, and the court can make a decision. So, you know, when Mr. Mobb's background is looked into, if it does raise domestic violence issues, then I'm going to let the guardian ad litem determine that. And likewise, when the kratom or alcohol issues are looked at, if the guardian ad litem feels additional evaluations are appropriate, I'm going to let them determine that. I'm not going to do that today.
Your Honor, just so you're aware, my client has done the eval recently, and this should have been collateralized. We will follow that with the court as soon as we get it.
All right. The way we do a guardian ad litem is I give 3 names to the parties. The attorneys have an opportunity to strike one of the names. And so do you have those names?
I practice a lot in Pierce, and that's their method as well, so.
Okay, so here are the names from the clerk. Why don't you tell them to me and I'll.
Keith Lawrence.
Okay.
Heather Kale. Amy Turnbull.
So it's Keith Lawrence, Heather Call, and Amy Turnbull. And typically we pick the first person unless they're struck by one of the councils. So let me go to Ms. Winkles. Are you going to strike anyone?
What were those names one more time? I'm sorry, cut out a little bit.
Okay, sorry.
Unfortunately.
Keith Lawrence, Heather Call, that's Kahl, and Amy Turnbull.
I'd like to strike Heather Call, Your Honor.
Okay. Council, I'm assuming you probably don't know any of these folks.
You assume correct, Your Honor, but we're willing to roll the dice with what you got.
All right, so I'm going to appoint Keith Lawrence.
Oh, we don't get to strike someone?
Oh, you can if you want. Go ahead.
No, Your Honor, we'll trust your judgment.
I thought roll the dice was go ahead and
No,
select somebody.
I mischaracterized, you're right.
Okay. All right, I'm going to appoint Keith Lawrence. Initially, the order will say that both parties pay 50% of Mr. Lawrence's fee. However, if someone feels they cannot afford that, you can file a request to have that party's portion paid by the county.
Your Honor, is there a set retainer? Pierce County requires $1,800. I don't know what Collins does for that.
We've recently changed that. And it's actually somewhat around there. The total amount is $3,300 before they need to ask for more. But Mr. Lawrence, I believe, asked for something like half of that. So that would be a little over $1,500.
And is that paid into the registry or directly to Mr. Lawrence?
Directly to him, and he puts it in a trust account. So if he doesn't use it all, then there'd be a refund.
Thank you.
All right. Let me go to the child support issue. I do have worksheets that were submitted by Ms. Doss. Mr. Sosa has indicated that he hasn't seen a worksheet from Mr. Mobbs, and honestly, I can't find one that's
Your Honor,
labeled as such. And
we did file those worksheets on the 17th of March. I'm a little concerned that they're not in there because we filed them. We also filed additional pay stubs.
I don't see anything characterized as a worksheet. So here's what I'm going to do. I don't think I can make a final decision on the temporary child support. I would like Mr. Mobbs for April to pay $1,000 in child support to Ms. Doss. I would like Ms. Winkles, go ahead and resubmit your worksheets and child support. And I'll put this over 2 weeks so that I believe Judge Fassett can make a decision at that time.
And that's fine, Your Honor. We will make sure that we submit all that information.
Okay.
And can we get a copy from you, counsel, or do we have to get it off us?
No, absolutely. We have submitted it to the court and yourself. I'm not sure what happened, why neither of them got there. We have submitted them. We will submit additional. We should have HR within the next few days. I will submit that to everybody as well.
Let's resubmit the worksheets. And
Your Honor,
so
before we-
there'll be Mr. Sosa, go ahead.
I did not hear a ruling on deviation, so we can at least get a worksheet that we can agree on without talking about deviation, because I don't even know if that was planned. So it was kind of a sua sponte.
I'm going to let Judge Fassett make a determination on that, but she's going to have to look at the visitation schedule I put together and determine whether a deviation is appropriate.
And is that going to be something she's going to look at in camera and make a decision and issue an order, or are we appearing again?
Oh, you're appearing, I'm telling you, you're appearing on April 11th, which is 2 weeks from today, to address the temporary child support issue in a little more detail.
Okay.
But in the meantime, Mr. Mobbs, I want you to plan on sending $1,000 this month. Now, will that go directly to your client, Mr. Sosa, or does she have the Division of Child Support involved?
It's DCS, I believe. No, it's not DCS. I have to ask my associate who's right here because she knows those details better.
All right, would you let Ms. Winkles know so that
Direct to her.
Mr. Mobbs
Direct to her.
knows where to send that money?
Direct to Ms. Dawes.
Okay, let's do that for April. What did I miss?
I believe
Fees.
you've gotten everything, Your Honor.
Fees. We requested fees.
That's
And Your
right.
Honor, and if I could just say, at $30-something an hour, that's almost
I think we've heard
$70,000.
argument already, Judge.
There is no need in this case.
I thought
and
we
that
were done
is-
with argument, Judge.
Ms. Winkles, give me some time here. Again, I guess my first decision on this is I do think the fees are appropriate given the difference in income. So at this point, I'm going to order $2,000 paid in 90 days. That's to allow Mr. Mobbs to pay that out of the income that he makes over that time.
And does interest start after the 90 days or now?
And I didn't
We
think we had an
haven't-
argument on this.
Just a second, you don't get to copy my argument. It's a question. Does interest start now or after the 91st day?
Ms. Winkles?
Your Honor, we didn't actually argue attorney fees, neither of us did. And the fact is that the statute is very clear. When you have a relationship that is not benefited by marriage, it is a need-based versus
This is
the
a
ability
divorce.
to pay. And there is no divorce here. You have two people that are not married, which means it's
Sorry,
need-based.
I did.
She
make a-
makes over $30 an hour. The fact is that interest is not appropriate, attorney fees are not appropriate, and that she makes almost $70,000 a year, just about $30,000 more than the average person in Cowlitz County. We have now at $2,000 a year. The fact is that interest is absolutely not appropriate. This is a case where we have withholding, we have dirty hands, and more than that, the statute is very clear when you're not married that it is a need-based and the ability to pay. While my client may have the ability to pay at $30-something an hour, there is not the need. This is a woman that makes over $70,000 a year. Attorney fees are not necessary, but more than that, interest is absolutely ridiculous.
Your Honor, I'm sorry, Ms. Winkles. Your Honor, I think Ms. Winkles would be absolutely correct if a CIR was pled, which, as you noted at the start of the hearing, it was not. So it's not before you today.
It's in RCW 20.
Let Mr. Sosa complete.
This is a standalone parenting plan. And CIRs are complex things. Right now, we're not there yet. And even if a CIR had been pled, as long as the cases are not severed under the law, you can award attorney's fees for the parenting plan component. Because as we are now, a standalone parenting plan. And whether you intended to or not, I think your parenting plan brain came forth because that's all that's before you. I think we're entitled to those $2,000.
I would like to brief this issue if Your Honor would allow.
Well, he's
because the
already
statute is
ruled.
very clear and the case law is very clear that attorney fees are not relevant in this case.
We don't have a CIR before us. Whether we intend to plead it or not, or all that, and there's no financial declaration from the other side. They get to, not throw anything at us. And by the way, take a look at my 2020 stuff. We don't have a worksheet. I think the $2,000 is awarded. Ms. Winkles can revise if she thinks this is an improper ruling, but it's not under the pleadings before you.
If Your Honor will allow me, I'll brief the case law that's come out in the last 5 years about parenting plans, about the need, about the income threshold, and about my client's income. I will also provide his income now. But the fact is that the case law is very clear. And this type of case, Miss Morningstar is not entitled to attorney fees. I would be happy to provide a brief on that case law.
Okay, I'm gonna allow that. I mean, it's either I accept the briefing now or somebody moves to reconsider later. And I just as soon have it before me, so.
That's fair ball, Your Honor. I appreciate that.
Let's, I don't know that I'm gonna be able to get a decision to you by the 11th. And I do want you to go back to court to determine the temporary child support. Why don't we have Ms. Winkles get me a brief if you can by April 5th?
Yes, Your Honor.
And Mr. Sosa, or your associate, get me a brief on attorney fees by April 12th. And I will rule as soon as I can after that.
So what does that do to our judge hearing next week? Or does that all put off?
Well, I guess that's what I'm struggling with here. Maybe we should move the hearing from the 11th to the 18th.
Okay.
So I can make a decision on the attorney fees. Does that work for you, Ms. Winkles?
Yes, Your Honor, that works for me.
All right, so we won't have you come back on the 11th. It'll be the 18th in front of Judge Fassett.
Thank you, Your Honor.
Okay.
Thank you, Your Honor. I know you read everything and I appreciate that.
All right, thank you, everyone. And appreciate everybody's arguments. Good luck to you. And I think that's it.